Okay, let's jump straight into it. The Supreme Court of the United States, they're set to do a decision based off of the Bruin case. I don't know if you heard of it or been staying up on what's going on, with the court systems and everything and the Constitution. But there's a big deal going on right now across the country, which may change the landscape of the United States as far as gun bans and everything. Um, there it is, right there. You know, let's read some of it. Third Circuit holds that application of felon in possession ban violates the Second Amendment, creating circuit split. Now, what that means is that some courts said that it was unconstitutional, then it was some courts that said that it was constitutional. But the thing is, if you examine what they filed and what the case is basically about, there's no way around it. It is unconstitutional on its face, as it's read. So, in Range versus Attorney General, the U.S. Court of Appeals for the Third Circuit, sitting in bank, struck down an application of a federal statutory provision, commonly referred to as the felon in possession ban, that prohibits individuals convicted of certain crimes from possessing firearms. The ruling follows the Supreme Court landmark decision and New York State Rifle and Pistol Association Incorporated versus Bruin, in which the court announced a new historical tradition standard to assess laws and regulations challenged under the Second Amendment. Although courts have upheld many existing firearm regulations under this standard, the Third Circuit joined a growing number of courts in striking down firearm regulations and became the first circuit court to find the felon in possession ban unconstitutional. The Third Circuit's decision not only broke new ground, but also created a circuit split, as the U.S. Court of Appeals for the Eighth Circuit upheld the felon in possession ban under the Bruin standard in United States versus Jackson, issued just 4 days before the Range case. Now, as you can see, with that being said, yeah, it's a lot that may go on with this, and it's set to the state United States Supreme Court is set to give a decision around the end of next month, June. So I'm not going to read it all, but I'm going to read this context. The Second Amendment to the Constitution states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Supreme Court first interpreted the Second Amendment as creating an individual right to possess some types of firearms for the purpose of self-defense in the 2008 case of District of Columbia versus Heller. The court further held in the 2010 case of McDonald versus City of Chicago that the 14th Amendment court incorporated this individual right against the states, making it enforceable against both the federal and the state governments. In Heller, the court emphasized that the individual right was not unlimited and that the government could still regulate firearms in many ways. Now, they they it's been a battle, but it's been a fast battle. This has been moving through the courts and moving across the country very, very fast, unlike anything else. You know, Heller and McDonald left unresolved a number of questions, including whether the Second Amendment protected conduct beyond using handguns in the home for self-defense and the constitutional standard courts should use to analyze firearm regulations implicating the Second Amendment. In the wake of these decisions, lower courts coalesced around a two-step approach for analyzing the constitutionality of firearm regulations. First, courts analyzed whether the regulated activity fell within the scope of the Second Amendment's protection. If not, the regulation posed no Second Amendment problem. If so, courts generally applied a means-end scrutiny, balancing the public interest in the regulation with the burdens of the restriction. Courts disagreed on whether to apply strict or intermediate scrutiny, two legal tests courts use when analyzing other constitutional challenges at this step. And Bruin, the Supreme Court refined and clarified Heller and McDonald. The Bruin Court held that an individual's right to possess a handgun for self-defense extended outside the home and rejected the lower court's two-step approach as one step too many. Instead, the court explained once a court determines that a regulation implicates the Second Amendment's protection, the law is presumptively unconstitutional unless the government establishes that it is consistent with the nation's historical tradition of firearm regulation. The court added that this standard requires only that the government identify a well-established and representative historical analog and not a historical twin. So what that means is that they have to show on the face that they have been regulating this since the Constitution was formed, in which it's not there. It's not there at all. Applying this standard to the New York law at issue, the court identified no historical analog to New York's requirement that a person seeking a license to carry a concealed pistol or revolver demonstrate good moral character and proper cause. Accordingly, the court struck down the New York law as violating the Second Amendment. Now, I'm not going to read all this, but as you can see, this is going on right now, and so felons may be able to possess guns. You know, not saying that all felons or whatever at this point, but at least nonviolent or but as it goes, it says that it doesn't matter if it's violent or nonviolent if you read a little further. But what I do is, if you want to, look into this further, I'll leave, the link in the description, and you can follow it and you can read it for yourself, and that'll be that. All right, now get at your boy.